Jared Lepick versus Andrew Elliott.
Yes, I'm here.
And are Elliott and Burrell. Are they here?
I'm here, Your Honor.
Elliott's.
Why aren't they here?
I'm here, Your Honor.
Ms. Burrell was dismissed. She's not a party and she's not a lawyer.
Your Honor, if I may.
Go ahead.
I have evidence. I didn't know whether I was still allowed to appear in person as a result of the notice to have me dismissed. My partner is not able to get off work, but I have evidence for the court in defense of my partner.
Ma'am, I see now the notice of dismissal. You've been dismissed from the case. He's not here. He needs to be here.
Understood. I've been messaging with my partner to see if they can do something to make it. On the meantime, I do have evidence that I have been given that I can put forward.
He needs to be here.
Okay.
If not, I'm going to default him because he needs to be here.
Understood.
When is he going to get here?
I don't know. Again, my partner is in the middle of work, doing everything that can be done to be present.
Well, it's to be fair to each side. I give him 20 minutes. He's got to be here. If not, I'm defaulting him. Will that work for you, Mr. Lloyd?
20 minutes it is, Your Honor.
All right.
It'll be 10:15 our time.
Okay, that works. Lepick versus Andrew Elliott.
Yes, here.
That's Mr. Lepick, right?
Yes.
Your Honor, I'm appearing on behalf of
Andrew Elliott. No response. Would you like to take a default? I gave you.
Your Honor.
All right, raise your right hand. Do you solemnly swear affirm testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Go ahead, your claims.
Your Honor, there's doing already right now in the amount of 15,000. There is back to water bill that hasn't been paid in the amount of 584. There is a question, Your Honor, about late payment charges, and if you want, I can address those. The court had commented on in the last hearing, and because of the amount.
Yes, and they were rather large.
Might I make a pitch?
Certainly.
Your Honor, what's going on in this case, I agree, as a purely landlord-tenant case, the amount of the late payment penalties is large. But in the context of the sale of the real property based out of earnest money and late performance of a purchase agreement, the amount is perfectly normal. I mean, I'm told that this was a $700,000 home being sold normally 1% or 2% of earnest money. And so in terms of a good faith attempt for the parties to establish a number that could reflect the consequences of the default, I think the late payment charge is large, but not unconscionable. I don't know what the standard of the code like.
I think it is, well, I would say that the late fees are unconscionable, and also the late fees can't be liquidated damages. In the scenario you put up, they could be in a certain respect. In this instance, the late fees have to be related to the landlord's ability to collect rent in some reasonable amount. So I would not allow them. If you want a hearing on that, you show it to me, then.
I see it a different way. In the context, I think I am less shocked because I see 2% would be a typical earnest money deposit. This is less than that. but in the context of monthly rent payments, I'm not gonna make that argument. Your Honor, there is now, we have an not earnest money, a security deposit that I want to be applied. I've got damages of $15,584. We'd like to apply the security deposit of $8,550, and what we'd like is a judgment in the amount of $7,034. I don't have my costs.
7,000.
034.60. Now that's the net judgment.
After application of the
After
security.
application, I have a judgment for the.
So here's what I would do. I would take your total, make it clear under the further orders provision that the court is permitting this security deposit to be deducted since they vacated the premises, so that the full judgment is actually the full amount, and then the security deposit being deducted, so that we don't have, because I think there's going to be a problem if we do it the other way.
I have prepared a form, if you can see, let me fill it out. I'll prepare it, I'll offer to the court and I've got it right.
All right. And your court cost in this case, I have 130. I don't,
Process, so we go and we got 75.
I have the process serving, I have a 0 service fee on both. I have no service fee. Okay.
So that would give us 205, I believe. And
Yes, 205.
I will present it.
All right. Thank you.